papers, and we'll be starting with Ankit, whose paper, very interesting topic of ineffective international cultural heritage law in Indian courts. So Ankit, I'll hand over to yourself. Again, I'll try and keep time, 15 minutes per paper. What I'll do actually, if it would be helpful, Ankit, is I'll use the raise hand function in Teams to let you know when you've got about a minute left. Is that okay?
Either way is fine, but I'm going to watch time on my device here as well, so that I don't cross the proverbial line. With those words, I thank the organizers for giving me an opportunity to share my thoughts. Insofar as cultural heritage and public law is concerned, we stand at a solemn crossroad of history and law. Our cultural patrimony, which is priceless and irreplaceable, has been slipping through our fingers, not by acts of conquest, but by a silent plunder of illicit trade. In the hallowed cities of Chandigarh, a city born by Nehru's vision and Le Corbusier's genius, we witnessed a microcosm of global malady. Incidentally, I speak from this very city and is my home city, so this paper is particularly close to my heart. The furniture, which is of question over here, is by renowned modernists Le Corbusier and Pierre Jeanneret. These objects of importance are movable objects of chairs and tables in nature, which were once humble servants in public buildings, which have now become orphans of our neglect and the darlings of foreign auction houses. But this is not lamentation of aesthetic alone. It is an indictment of legal shortcomings, both international and domestic. Perhaps one is reminded of what Churchill would have probably called as the tiny island defying a great tyranny which refuses to be extinguished despite the odds. Our charge is clear in that regard, is to ensure our cultural treasures are preserved, be they ancient idols or modernist chairs. These do not become mere spoils of the international market, as we do see now, and you see on your slides as well. This trade essentially starts in the early 2000s, where self-made teak and cane chairs and desks began to vanish from the city offices and reappeared in galleries in Paris and New York. One of them is infamously sold for £50,000 in an auction in Chicago. This belonged to Pierre Jeanneret, and thus began the cyclical nature and a nexus of neglect and greed. Unscrupulous dealers exploited local indifferences, bribing officials and scavenging in government storerooms for what was deemed to be junk. Thieves stole artifacts from public institutions, and smugglers forged documents, at sometimes even faking certificates to the Archaeological Survey of India, to spirit away Chandigarh's spirit through sea routes. A big breakthrough 2016 study showed the Directorate of Revenue Intelligence arrest a smuggler in the southern region of Bombay linked to these heists. However, despite a handful of arrests, the largest smuggling network persists, Hydra-like evading full dismantlement. Yet this failure is not of policing alone, it is a failure of law and of mere Indian law, and that. For these artifacts do not vanish into thin air, but they surface into bright auction houses, lights in London, Paris, and beyond. And they carry India's legacy and a cry that India runs through and through the legal barricades in foreign courts. There are frameworks in place, but these frameworks, such as the 1970 UNESCO Convention on prohibiting and preventing illicit import and export of cultural property, is a noble covenant aiming to ensure that no nation's heritage could be plundered for another's gain. India is proud to be a signatory, but the cold reality of enforcement is that international frameworks have proven to be timid and toothless in practice. These conventions carry with them no domestic will in the system. When India sought to stop a auction in Paris in 2008 featuring chairs from my city, the French law stood aloof, demanding definitive proof that the pieces were stolen or smuggled. In effect, the burden of proof fell on India to demonstrate illegality, and without immediate ironclad evidence, the sale proceeded. Further, in 2011, French customs seized over 50 objects and artifacts in another auction. They lacking comprehensive records, these were, after all, not gold coins or ancient idols, but modern chairs, not catalogued in museum ledgers. India struggled to satisfy foreign courts, and some pieces were eventually returned, but only after a protracted ordeal. The United Nations Convention, the 1970 Convention, is also not retroactive. It only applies to artifacts illicitly exported after the convention into force. So if a Jeanneret chair was left in India in 1965, when a few recognized its value, international law today offers a scant remedy. The convention also lacks a strong enforcement. If the market country does not cooperate, the convention alone cannot act for restitution. Here's another example. In 2015, Chandigarh's sofas traced in Switzerland required India to prove illegal export under Swiss law. The Swiss authorities were unmoved without clear evidence. International law in these circumstances and instances provided a pious aspiration but little practical aid. Never in this sense has been hoped for so much in international unity, and yet so much been lost to a lack of a unified action. What about Indian laws? The Indian law on antiquities and arts and treasures of 1972 is the bulwark of our cultural protection, but it remains a primary regulation for regulating export and trade of antiquities. However, here is the punch. The act is stringent. Any artifact over 100 years old cannot be exported without government permission. However, in paper it aligns with UNESCO's spirit. However, in practice, the act is aged poorly and addresses only a slice of our heritage. By quirk of the definition, 110-year-old colonial objects or tables, which are antiquity, may be understood, but a 70-year-old modernist chair from a great historical value or understanding does not. The Archaeological Survey of India itself turned down a plea to declare Corbusier or Jeanneret furniture as art treasures, as they don't fall within the convention. Chandigarh's heritage simply is not considered as antiquity or art treasures under the current law or the regime. There are, of course, other papers that I discuss in this paper. I'm also not entirely a researcher, but an advocate, and this, I hope, would become part of a public interest litigation or a class action lawsuit, wherein the administrators will be brought to court in a way wherein foreign auction houses can also be involved, and some sort of a legal recourse can be provided. However, enforcement challenges are difficult, because what renders these cases so difficult to prosecute or adjudicate are as follows: provenance and documentation gaps. For Chandigarh, or the chairs or idols, record keeping does not simply exist, and in foreign courts, this is absence of provenance weakens India's claims, as seen in Paris and in the Swiss cases. Without documentation proving an item's origin, an illegal export for our pleas is entirely dismissed. The burden of proof or the source of the nation is also important to be determined, to prove that the fact was illicitly removed rather than the holder having to prove lawful acquisition is another hurdle. What about the jurisdictional or procedural hurdles? Indian courts have jurisdiction to try theft or illegal export that occurred on Indian soil, but what if they cannot summon foreign auctioneers to answer in an Indian trial, nor easily retrieve objects from overseas without cooperation of foreign courts? We rely on mutual legal assistance treaties and diplomatic channels, but let's face it, how difficult is that in other circumstances? What about the practical realities and investigations of these thefts? Delay, in some sense, is the ally of the smuggler. The longer a case drags, the more likely the evidence is to be lost, witnesses forgetting details, or the artifacts disappearing from trace. In sum, what I suggest is that enforcement in Indian courts is a combination of legal definition issues, what qualifies as protection, evidentiary burdens, cross-border jurisdiction limits, and resource constraints. What therefore perhaps could be a path forward? It is important to acknowledge that the curse of this darkness, and we must hold a candle or light in this regard, and develop a documentation or a provenance or a history or a comprehensive inventory of these documents. Documentation can transform our heritage from orphaned objects into identifiable ambassadors of our culture. With clear records, we can swiftly produce proof for foreign courts and also deter theft by making it known that every piece is accounted for. There also is an Interpol work of art database which proactively scans international auction houses and coordinates with customs at ports. This expertise must be also cultivated. Additionally, the process of certifying an object as an antique should be streamlined. The ASI in India must be empowered and obligated to respond rapidly and rigorously when enforcement agencies seek an expert. No longer should a case fail because an official was uncertain or procedure was too slow. The Arts and Antiquities Treasured Acts of India, which you saw on your slides earlier, is also not sacrosanct if it no longer serves its purpose. A thorough review and amendment of this law is imperative. The definition of antiquity should be broadened and be much more flexible. Another critical example in this regard could also mean or reflect like the cost of doing business in these regards. We must signal that stealing a statue or smuggling an artifact is a serious crime on par with other organized theft. Lastly, we must clarify the legal procedures. For instance, not just ASI but also the police to seize suspects for the antiquities and proper safeguards that would allow for technical arguments that cannot later be nullified. In short, we must modify and modernize the 1972 Act into the 21st century. And I'll be happy to offer examples in this regard in the question and answer session. However, we must also look at examples of bilateral agreements, as perhaps one we have with the United States of America. But what remains more important is our agreements and understanding with our European friends, because the trade of such objects has been found much more prevalent there. However, India could also consider ratifying the 1995 UNIDROIT Convention on stolen or illegally exported cultural objects, which provides for private claims and return of cultural property, offering another tool in the arsenal of recovery. Therefore, what we must enact are reforms out of despair, but out of the belief that we can shape our own fate. However, in conclusion, what perhaps remains important in this regard is that at the end, this perhaps might just be the beginning. Must not surrender to the heritage and the spectral silence of foreign galleries or the cold commerce of international auctions. We must fight as legislatures, as prudent laws. We must also fight in these courts and compel with evidence and eloquence. We must fight and try and find some sort of a solution in this regard. If we succeed in reforming our laws, we reinvigorate the system and enforcement, then in decades hence historians and audits our deeds that they will say that this was perhaps the hour which was of utmost importance. We must cherish this, and we must not lose our heritage to thieves, nor left to the indifference, but preserve the generations which must have the ability to enjoy our history and heritage, and not be curtailed by limitations of this regard. Let us use these sources and stories not only to reform, but also to impel us to act. The law must have to be not just ineffective in the past as it has been, but perhaps steadily grow and resolve and be reformed wisely. We must ensure that it will be effective in the future, and that the cultural soul of India shall be guarded, be that as it may, as it is now. With those words, I once again thank the organizers, and knowing that I have left 2 minutes, I do hope those are some sort of brownie points to me.
Thank you so much, Ankit.